Hi, everyone. We're going to get started in just a second. Just going to give everyone another minute to join. All right, I will go ahead and get started. Good evening, everyone, and welcome to Big Changes, Big Decisions, what the new laws on student loans mean for you. My name is Jordan Daniels, and I'm a paralegal at the Empire Justice Center. We are here today to discuss federal student loans and all the changes that we can expect to come as a result of the new litigation, legislation, and just the shifting federal landscape. Thank you so much to Assemblymember Romero and her team for having us today. I'm going to pass it over to her to say hello, and then we will get right into it.
Great. Thanks, Jordan, and thanks so much, everyone, for joining us tonight. I am Assemblymember Gabriella Romero. I represent the 109th Assembly District, and I'm really so glad to partner with all of y'all for this really important conversation. As I'm sure all of you know, student loan debt touches pretty much every single family in our state. There's about 2.4 million New Yorkers carrying around $98 billion in loans. And that burden is pretty intense now, as Jordan mentioned, with the federal intensity that's happening. And this webinar is just about kind of clarifying everything that's going on right now and giving you just a little bit of relief. So I'm really excited to partner here. I'm such a great supporter of the folks that are doing this work. And I'm just really so proud of the work that EDCAP is also doing, a program that provides free expert counseling to help borrowers really navigate the system, reduce stress, and in even some cases, eliminate debt. So tonight's workshop is really all about a chance to get really clear, actual guidance about what is actually happening in this chaos and crisis mode. Personally, I have a lot of student loan debt from law school, so I will be watching back this webinar. It's going to be recorded and really look forward to kind of hearing back from all of y'all about this webinar as well. So thank you again. I'm going to pass it back to Jordan, and I continue to be your advocate in the New York State Assembly. My door is always open to you. So thank you again for coming, and passing it back to Jordan.
Thank you, Assemblymember. All right, I am going to go ahead and share my screen. Let's see here. Going. Oh, 1 second. There we go. And Carolina, does this look good to you?
It looks good.
Okay. So, as I move through the presentation, if anyone has questions, please feel free to just pop them right in the Q&A feature. I will pause occasionally throughout the presentation to answer any relevant questions, and I'm also going to leave time at the end for questions. I will be sending out a copy of this presentation to everyone who registered for the webinar so you can refer back to it later. So let's go ahead and get started. All right, first we have our agenda. I'm going to talk a little bit about our program EDCAP, give you some important updates on what's happening federally, go through the strategies for tackling student debt, including your repayment options, how to pursue different types of forgiveness like income-driven repayment forgiveness, public service loan forgiveness, general guidance for income-driven repayment for borrowers because a lot is changing coming up. If you are totally permanently disabled, talking about your options there for eliminating debt, and then also what to do if you are in delinquency, default, or experiencing collections on your federal student loans, and then just some relevant links and contact info at the end. All right, so EDCAP stands for the Education Debt Consumer Assistance Program. This program is created by the Community Service Society of New York. Empire Justice Center is one of 12 community-based organizations that provide these comprehensive free student loan counseling and educational presentations across the state. Empire Justice Center provides these services to borrowers in the greater capital region. And through our helpline and network, we can, help you determine your best loan repayment strategy, help you access loan forgiveness, discharge, cancellation. We help you apply for free, consolidation, deferment, and forbearance. This stuff should never cost money. We help you resolve issues and mediate issues with servicers and lenders. We can help you get out of default to prevent, wage garnishment, Social Security offsets, tax intercepts. And we also tackle it on the back end by providing pre-college counseling services and FAFSA assistance. So to help you make better choices about obtaining debt in the first place. So all of that and some more, I'm sure. All right, so let's get right into the important updates. So let's talk about HR1, or some people refer to it as the tax and spending cut bill or the big beautiful bill. I will not be referring to it as that. I will be choosing HR1 for the purpose of this presentation. So this bill introduces major changes to the student loan system, and now that it has passed, these changes will start being implemented over the next 1 to 3 years. These changes include borrowing limits, new repayment options, and the sunsetting of existing options, changes to income-driven repayment forgiveness, and the elimination of some short-term financial relief programs as well. So we're going to dig right into these changes later. But I just want to note that this bill does not alter public service loan forgiveness at all, which forgives loans in 10 years for those working in public service jobs like nonprofit, government, public schools. There is a negotiated rulemaking process underway right now that might limit certain organizations' eligibility for this program in the future. However, as of today, no changes have been made to the program. So the SAVE plan, which was introduced by the Biden administration back in 2023, it was the cheapest income-driven repayment option that was available to borrowers pretty much ever. That is going to be eliminated. A lot of you may find yourself on forbearance due to the pending litigation against the SAVE plan. Regardless of this result, the new bill eliminates the SAVE plan. So for borrowers that are currently on the SAVE forbearance, it was extended until October 31st of 2025. It is important to remember that the time spent in this forbearance does not count towards forgiveness, and interest began accruing again on this forbearance as of August 1st. So there's approximately 7 million borrowers that are still enrolled in SAVE, but they are being asked, to slowly transition to another plan within the next few months. So you can submit an application on studentaid.gov to enroll in another plan as soon as right now, but you definitely want to make sure that you understand your options before you do that. All right, so federal student loan collections have restarted. In April, the U.S. Department of Education announced that it would resume collections on defaulted loans starting May 5th of 2025. It was paused starting in March of 2020, but as of the end of May, it has already collected over $100 million from borrowers. In early June, the Department of Education paused collections on Social Security benefits, but it says that they probably will start them again later this summer. They have not mentioned any pause on tax refund intercepts, wage garnishment, or other federal payments. It seems as if those are not moving forward as of right now, but nearly 10 million borrowers could be in default very soon, which is about 25% of the total loan portfolio in the United States. So what does this mean for you? If you are in default, you may receive notices about Treasury offsets like tax refunds or Social Security garnishments prior to the pause. And later this summer, potential wage garnishments may also be eligible for collections again. You will get an email communication urging you to contact the default resolution group or another guarantee agency that might be handling the default. Some people who have FFEL loans, which are federal family education loans, they are handled by a different agency, but you should make arrangements with them to resolve your debt as soon as possible. If you have defaulted loans and are on Social Security, use this time wisely since they are not collecting to get your loans back into good standing. And we will talk about how to do that towards the end of the presentation. All right, and then some other changes. The Department of Education has experienced a major reduction in workforce. They have gutted some of the major offices like the Ombudsman's Group. They were responsible for resolving disputes between borrowers and servicers. This has left multiple departments severely understaffed, which has led to a whole host of problems, including, delayed processing times, unanswered complaints, and just general inquiries going unanswered. If you have an issue with your student loan that is not being resolved by your servicer, you can still submit complaints through the Department of Financial Services. Or we've also had a lot of success going through elected officials, so who can assist you with kind of creating a connection with the Department of Education and advocating for you on your behalf. So another one, the president announced obviously that the federal student loan portfolio would be moved from the Department of Education to the Small Business Administration. This must be done through Congress. There are no provisions in HR 1 that permit this to happen. If it did, loan details, repayment, forgiveness options, those would not change. But as of right now, no actual movement has happened on this. So we should just stay tuned for further updates on that. And then also recertification dates have been pushed back. If you are enrolled in an income-driven repayment plan, you must recertify every year to update your payment amount. All direct federal loans and federal family education loans have had their recertification dates pushed back to the earliest being February of 2026. Make sure to monitor your account to ensure that you know your recertification date and that your that your payment amount is accurate to what you signed up for when you signed up for the plan on studentaid.gov, because we have had reports of inaccuracies and troubles with processing. All right, so what should you do right now? Honestly, our best advice is that you should stay vigilant and keep good records. It has been proven time and time again that you cannot rely on the Department of Education to keep good and accurate records of your debt. Keep loan details from your federal student aid account, confirmations of any payments that you made, information from the PSLF tracker on federal student aid, any relevant notifications you get in your servicer inbox. All of these are important to keep. And honestly, I would keep this going on a monthly basis, only because, especially if the transition to the SBA happens, we can guarantee that we're going to lose some vital information there. All right. So let's get into the specifics about the changes that are going to happen as a result of HR 1 passing. So the first one is going to be borrowing limits. So this is effective July 1st of 2026. Direct subsidized and unsubsidized loans for undergraduate education, there's not going to be any change to borrowing limits. However, direct subsidized loans for graduate school or grad plus loans, if you're pursuing a master's degree, you have a $20,500 annual limit and a lifetime limit of $100,000. If you're pursuing a professional degree like a law degree or medical school, you have a $50,000 annual limit or a lifetime limit of $200,000. Grad plus loans in general will be phased out starting July 1st of 2026. An exception is if you have grad plus loans dispersed prior to July 1st, 2026, you may take out additional loans to finish the degree that you are already pursuing. But in terms of starting a new degree, you will not be able to access grad plus loans. And then Parent Plus loans, they will have an annual limit of $20,000. Your lifetime limit is $65,000 per child, and this includes both parents. So parents and graduate students are going to find a huge deficit in what they were able to borrow compared to what they were able to borrow before. So they may be forced into the private market if they are eligible to fill those gaps. And the private market comes with a whole host of other issues. They don't have nearly as many protections as federal student loans. You're subject to variable interest rates rather than fixed interest rates. It can be you need to be very cautious when pursuing private loans. All right. And then there are also some major changes for borrowers obtaining student loans for the first time. If you're a borrower whose first loans are being dispersed on or after July 1st, 2026, you will only have two options for repayment. The first being the fixed standard repayment plan, which has a payback period of somewhere between 10 and 25 years, depending on your debt size. And the second option will be the new income-driven repayment plan called RAP. This stands for Repayment Assistance Plan. The RAP plan calculates your payment somewhere between 1 and 10% of discretionary income, depending on how much you make. The payment is reduced by $50 for each independent that you claim on your tax return. You have a minimum payment of $10 a month. There are no more $0 monthly payments on this plan. Every borrower, even if they are unemployed, have $0 income, will be paying at least $10 a month. Spousal income can be excluded when evaluating the price for this plan, as long as you are married filed separately on your taxes. There's no protected income, no adjustment for inflation, but unpaid interest will not accrue, meaning that if your monthly payment does not cover the interest on the loan, your balance will not increase. It does offer forgiveness after 30 years on this plan, but it will be the only plan that new borrowers can be on in order to pursue forgiveness, things like PSLF or income-driven repayment forgiveness. If you take out new loans after July 1st of 2026, all of your loans must be paid back under the same repayment plan. The only exception is people with mixed debt portfolios, for example, like a Parent Plus borrower who has debt out for their child, but also has their own loans for their own education. The only reason that this is allowed is because Parent Plus loans are not qualifying for RAP. So they might have some on standard plan and some on the RAP plan. Right. And then repayment plans for legacy borrowers. So legacy borrowers, we're considering people who have any loan dispersed before July 1st of 2026. The following rules will apply. So after July, well, these borrowers can still access plans like pay as you earn or payee, income contingent repayment or ICR, and a modified version of income-based repayment or IBR until July 1st, 2028. After July 1st of 2028, any of these legacy borrowers will be transitioned to the IBR plan. The modified version of the IBR plan is effective immediately. It will have no income test, but payments continue to be capped at no more than the cost of your standard 10-year fixed repayment plan. So payments for borrowers with any loans dispersed prior to July 1st, 2014 will be calculated at 15% of your discretionary income, and balances will be forgiven after 25 years of qualifying payments. And then payments for borrowers whose loans were dispersed after July 1st, 2014 will be calculated at 10% of discretionary income, and balances are forgiven after 20 years of qualifying payment. So these borrowers also will be eligible for RAP if that ends up being the cheaper option for you, as well as the standard plan. And then important note, if a legacy borrower takes out new student loans after July 1st of 2026, you have now classified yourself as a new borrower. So you will be subject to the new borrowing rules. You will only be able to pay your debt back in the standard plan or the RAP plan, and you will lose access to the modified IBR. So you want to make sure you're very careful about taking out debt in the future, and then also about consolidation, because that could also classify you as a new borrower. Right. And then the last group to address is the Parent Plus borrowers, who I will never understand this, but for some reason are just given the short end of the stick in every major federal student loan decision. But the new Parent Plus borrowers that take their loans out after July 1st of 2026 can only repay their loans in the standard plan, even if they consolidate. HR 1 gave Parent Plus borrowers no access to income-driven repayment, including RAP, which means that they have no path to income-driven repayment or public service loan forgiveness. Legacy Parent Plus borrowers, so those with loans before 7/1/26, need to consolidate before 7/1/26 in order to enroll themselves in an income-driven repayment plan. These borrowers will be put on a modified version of IBR if they do so. These borrowers will not have access to the RAP plan. So the same rule applies if a legacy Parent Plus borrower takes out new Parent Plus loans after 7/1/26, they have lost their protected status and they become a new borrower. All of their debt will have to be paid back in the standard plan. So the lesson on this is if you are a current Parent Plus borrower, please reach out to us for assistance and double check that you are in the right position and that you don't need to consolidate, because that 7/1/26 deadline is vital. And then here's just an example, a little like scenario. So if we have a family size of 2, so a single adult with a dependent, you have a loan balance of $85,500. You can see the income on the left. On the RAP plan shows you what your percentage of income would be that they're considering depending on what your income is. And then over to the right, you have your amounts on RAP, modified IBR for 10% and for 15%. So these is just like a simulation of what you might expect if you were to place yourself on the RAP plan. I'm going to take a quick pause just because we just covered a lot. And Carolina, are there any pressing questions?
I can go over some. I also wanted to mention in the chat, I put a link to the webpage that has kind of all the information Jordan just went through in case you want to go back and segment it because it's a lot of information that even for us, it takes us a while to process everything. The other thing that I will mention is if you are in school this year, this coming year, like fall, spring, you could continue, as Jordan mentioned, borrowing up to the cost of attendance to finish off your program. So that's very important. We're getting a lot of questions from graduate students and parents on like how much can they borrow student federal loans. Any new borrower that starts taking out loans after this year, uh, again, if they're starting their program and if they're a Parent Plus, then you're going to be seeing some of those caps go into effect and you may be impacted. Um, there was a question about save, and there's a lot of confusion about save. So the
Mhm.
question was, do I need to switch servicers if you're on save? And the answer is no for servicers. So your servicer and sorry, I can come up on camera. Your student loan servicer is actually an entity contracted by the U.S. Department of Education to manage your student loans. They are not even your lender, they're just managing your loans. So if you're unsafe, you do not need to switch and you cannot actually switch student loan servicers. What you need to consider is whether you switch right now repayment plans. You can still stay unsafe until they officially kick you out. The forbearance right now is extended until October, TBD on whether that's going to get extended. But the only change that happened recently was that as of August 1st, as Jordan mentioned, interest started accumulating. So if you don't care about the interest accumulating or you're not pursuing a forgiveness program, interest is going to accumulate whether you stay unsafe or whether you switch plans right now. So be aware of that. But for people who may be pursuing forgiveness, especially public service loan forgiveness, we are recommending that they consider switching to actively earn credit. Because otherwise there's some challenges if you don't switch and are just in limbo. I think that was like the big question so far. As a reminder, I'm behind the scenes, so if you have any questions on any of this, feel free feel free to put it in the Q&A and I'll be happy to answer. Thank you, Jordan.
Thank you. All right, and then just some other changes that we can expect. Loans that are dispersed on or after July 1st, 2027 will not be eligible for economic hardship or unemployment deferments, and they can only be in forbearance for 9 months during any 24-month period. So they are starting to limit your amount of forbearance and deferment. And then effective July 1st, 2027, you will get 2 chances to rehabilitate a defaulted loan rather than your current one, which is actually positive. So it gives more people opportunity to rehabilitate their loan and get out of default. And then as for borrower defense to repayment, which forgives loans when a school engages in some kind of misrepresentation or misconduct against a student, and then closed school discharge, which forgives loans when a student is attending a school that closes while they are actively enrolled or closely after they withdraw. Biden era rules, which would have made discharges in these programs a lot easier, is going to be delayed until July 1st, 2035, due to ongoing court challenges. So it's going to be very difficult throughout the next few years to get BDR or closed school discharge. So we definitely want to explore our other options if we have them. All right, so with all that in mind, let's talk about some general strategies for tackling student debt. The first strategy is to pay off the debt in full as quickly as possible. This is a suitable option for borrowers who have like a low loan balance and a relatively high steady income. This strategy lets the least amount of interest accrue and can even leave room for lump sum payments if you have the money to do so. If you can afford this strategy, that's great. However, a lot of people cannot. So we look to our other options, like the second strategy, to pay the minimum amount required on an income-driven repayment plan until you reach forgiveness on a program of your choice. So those two primary federal programs are public service loan forgiveness and income-driven repayment forgiveness, which forgives your loans anywhere between 10 years if you're pursuing public service or 20 to 25 years if you're pursuing IDRF under IBR. Lots of acronyms here. And then if you're pursuing forgiveness under RAP, that's going to be 30 years. So this strategy is suitable for borrowers with high loan balances and like low to moderate income. This is a long haul strategy. There's no making lump sum payments to reach forgiveness quicker. You are in it for that 10, 25, 30 years, depending on which program you're pursuing. This is the strategy I'm taking with my debt. I know I'll be working in public service for at least 10 years. My loan balance is, about equal or a little less than my yearly salary. So this is my best option. And then the final strategy is to pay the minimum amount required until you can't anymore. This one always sounds like a little bleak when I talk about it, and it kind of goes against everything that we know about personal finance, but it is the reality for a lot more people than you think. This strategy is best for people who have very high loan balances compared to their income. Realistically, it's a situation where this person is never going to repay their balance with just the income that they receive from their jobs. So you would get on a payment plan that you can afford, and you pay that minimum amount until you can't anymore. I see this a lot in Parent Plus borrowers whose balances are super high, usually much higher than their income. I see it a lot in older borrowers whose balances are so old that they've just like tripled due to interest. There's no shame in this choice. Federal student loans are dischargeable upon death, and they can never become a burden of your loved one. So it is an option. All right, so let's do an overview of what our payment options are. This information is going to be blanketed with the overall understanding that some of these options will not be available forever, but we'll talk about what's available right now, or at least in the near future. So first we have traditional plans. These are your standard 10-year fixed payment plan, your extended plans, and graduated plans. Both the extended and graduated versions of the standard plan will be phased out as a result of HR 1. So the pros of these plans are they have more predictable repayment periods. You can usually pay your loan down faster, and there's no need for recertification or income verification because it's not based on your income. These plans are best suited for those with relatively high income compared to their debt size and whose overall goal is to pay off your loan. That being said, there are cons to these plans. The payments on them are usually much higher than average, at least higher than the income-driven repayment options, and they can be very challenging for those who are lower income. There is also very limited flexibility in adjusting your payments because they are just simply based off of your debt size and the length of your repayment term. And then most importantly, there is no forgiveness associated with these plans. So alternatively, your other option would be income-driven repayment. So your current options are income-based repayment, or IBR, pay-as-you-earn, payee, ICR, or income contingent repayment, and then payee and ICR will be phased out and unavailable after July 1st of 2028. Then next summer, the repayment assistance plan, or RAP, will become available, possibly sooner, but that's the official date. So the general pros of income-driven repayment are generally more affordable repayment options because they are based off of your income. You get loan forgiveness after somewhere between 10 and 30 years, depending on which program you're pursuing. They are the only eligible plans for things like public service loan forgiveness or income-driven repayment forgiveness. You used to be able to report sudden drops in income, or perhaps if you lose a job and become unemployed, you used to be able to do that in your recertification period. We are unsure with the new rules if you're going to be able to do that in between recertification dates, but we will have more news on that soon, hopefully. And then these plans are best suited for those with, again, low to moderate income and anyone who's pursuing any kind of forgiveness program. Some cons associated with income-driven repayment is that you do have to renew and verify your income on a yearly basis. If you forget, they do kick you onto the standard plan, which can be very unaffordable for some people. More interest does accrue on income-driven repayment over the life of the loan. But if this isn't so much of a con if you're pursuing forgiveness, only because we have to remember the end goal is to get the loan forgiven in total, interest and all. So if more interest accrues, we kind of have to pick our battles. And then on average, you are in repayment longer than if you were on one of the traditional plans. All right, so let's kind of go through the two ways that you can reach forgiveness. The first is going to be income-driven repayment forgiveness. All of the existing income-driven repayment options do offer some kind of forgiveness between 20 and 30 years of qualifying payments. Unlike PSLF, there is no employment requirement. Uh, da, da, da. The Biden administration gave sweeping credit for income-driven repayment forgiveness under something called the IDR account adjustment, which was an initiative that ran through June 30th of 2024. So for those with eligible loans, there used to be a tracker on studentaid.gov, which kind of showed how close you were to forgiveness. The new administration did remove that tracker with really no indication of when it's coming back. But there is a backdoor link that we can show you what your payment count is towards income-driven repayment forgiveness. If you log into studentaid.gov or FSA and you follow the link on this slide, which you will have when we send out the presentation, it should give you your payment count. It'll give you like this text file that's crazy, but you just read the required payments and the remaining payments, and you'll be able to tell how many you have out of 300. The payment count that you see there should be transferable, and you should be able to continue accruing credit under the modified version of IBR or WRAP if you decide to choose one of those new plans. All right, and then we have public service loan forgiveness. This program forgives your remaining loan balance after 10 years of repayment on an income-driven repayment plan in conjunction with working full-time, which is considered an average of at least 30 hours per week with a nonprofit or government employer. Any on-time, in-full payment made on an income-driven repayment plan after October 1st, 2007, which is when the program came out, while also working for a qualifying employer should count towards PSLF. So there are some exceptions, like periods of in-school deferment, some forbearances, or periods of default do not count. Your qualifying employment does not need to be consecutive, but you do need to be employed with the qualifying organization at the time that you apply. So as of right now, forgiven balances under PSLF are not taxable on a federal or state level. I would also argue that this is probably the safest way that you can reach forgiveness at this moment. So if you have qualifying employment, you should definitely apply to see what your payment count is. And then I'm sure we've all heard something about the PSLF buyback. This was the department's solution to those in the save forbearance so that they could still get PSLF credit for this time. The buyback would allow you to purchase months spent in disqualifying status, like the save forbearance, as long as you meet the following criteria. So first, you must have completed 120 months or 10 years of employment at a qualifying organization. That is step one, and you can't apply without that. Two, the number of months that you are looking to buy must bring you to 120. So for example, if your current payment count is at 105 and you're stuck in the save forbearance, you must purchase the full 15 months in order to bring you to 120. You cannot pick and choose a month here, a month there. You have to pay that full amount to reach forgiveness. You cannot purchase months prior to a consolidation. If you had to consolidate to be eligible for PSLF, months where you are on in-school deferment don't count. Months spent in the grace period after you graduate or any months in default do not count and cannot be purchased. And then the amount that you pay per month for the buyback is based on what you were paying in an IDR plan prior to entering the disqualifying status. And then immediately after exiting the status, whatever the cheaper of those two amounts is what you will have to pay per month for your buyback. You can request a buyback on studentaid.gov through the PSLF reconsideration form. The idea is that they would mail you back an offer with the amount that you have to pay in order to reach forgiveness. You would send it in, and in theory, that should forgive your loans. I will say, personally, the process is incredibly slow. Only 2,200 applications were processed as of June, and the backlog has increased significantly since then. I have had clients who submitted buyback requests in February, March, and they still have not heard back a single thing, but it is always worth trying, especially if you've already reached your forgiveness. You really don't have anything to lose, so it does not hurt at all to submit a buyback request. All right, I'll pause. Actually, you can continue to update your monthly employment, and we do encourage you to do so. by submitting PSLF recertification forms. These just verify that you've met the baseline requirement for PSLF. So that, when you are applying for buyback or if you're trying to establish what to do next, what plan to get on next, how much credit you have moving forward. You would submit one form for each qualifying employer that you've had since October 1st of 2007. You submit these forms annually or whenever you change jobs. We encourage you to do it annually just so you can keep yourself on track. Some people go their whole 10 years and submit it one time and get all their credit. I'm a little too crazy for that. I like to know where I'm at. So I do mine every year. We strongly recommend doing this through the PSLF help tool through your studentaid.gov account and requesting an electronic signature from those employers, because those are being processed the fastest. Manual forms, the Department of Ed has been cut in half. They just don't have the manpower to process some of these requests manually. So electronic signature is definitely your best move. All right, and now I'll pause again. Carolina, any questions?
Yeah, so there was like a really good question, and the question is around making extra payments. So one thing to understand about student loans, and I always say this, there's nothing special about them. If anything, they're the worst type of debt you could probably have because it never goes away. But there's no prepayment penalty. You can make extra payments at any point. The only thing that you might have to deal with, depending on your repayment plan, is they will put you in this pay ahead status sometimes. Hopefully, most servicers have addressed that. So, for example, if you are in a plan where it's not based on your income, but to be repaid within like 10 years and you make extra payments, your monthly invoice may be lower than what you usually expect because the system will account for that extra payment. But you can either ignore that, just continue making the minimum payment that your invoice, and you should get an invoice at least 21 days in advance. So be aware of that. A lot of people who are on the safe plan are like nervous, rightfully so, about when should I be getting a bill. We don't know, so we always say check your inbox, check your servicer account to make sure you don't miss an important notice. But going back to the payment, you can make extra, apply it. Now, if you're going to make a big lump sum payment, what I may recommend, if you have the time, is to call the servicer to make sure that they apply it the way you want it. So rarely does it make a big difference. But for example, if you're targeting one loan and you want that extra payment to go to one loan, you could call the servicer and request that. Now, you must continue to make your required monthly payments. Just because you paid extra on one loan doesn't mean you're not obligated to pay your invoice amount. So just be aware of that. No prepayment penalty. The other thing that I would suggest, if you are going to be paying back your loans because it's feasible and not pursuing a forgiveness program, I highly recommend using a calculator to estimate how much would you need to pay to finish within your goal, right? If you're telling yourself, I want to be done paying my $30,000 loan within 7 years, use a general calculator to know how much extra you would need to pay from your currently required amount, and that should be your guiding principle. I will say, related to that, a lot of the questions we get is around interest, and people pay a lot of money in lump sums and they feel like they're not putting a dent to their debt. And that's because when it comes to federal loans, you have your principal and you have the interest on the side. And so if you owe interest before anything goes into the principal, you have to pay off your interest. So, it's not uncommon for us to get clients who say, I just made a $7,000 payment and I saw nothing go down on the principal. And that's usually because there was a high interest balance there. So be aware of that. Again, you can pay your loans, you can pay extra. Just monitor your account to make sure that it's working the way you envision it should be working. And I think that's it.
And the most common questions that I get about prepayment, especially related to the save forbearance, if you've been in the save forbearance since, August 2024, whatever, over a year, and you've still been making payments, even though you were making payments, it's all about what status you are in. You are not in repayment status, you were in forbearance status, meaning that those payments, even if you made them and they were the allotted amount for you on save, they do not count towards forgiveness. And then the same thing applies for prepayment. You cannot prepay your way early to forgiveness because PSLF is a time-based program. Some people pay $0 a month to get credit towards PSLF. Some people pay over $1,000 a month. Does not matter how much you pay. Doesn't matter if you prepay or pay additional per month. You cannot reach PSLF forgiveness or any kind of forgiveness early by overpaying. So it does not help you at all. All right. So let's use all this information here and apply it to some of like the more common scenarios that I'm seeing in my counseling sessions right now. First, being borrowers who are enrolled in SAVE. So if you are enrolled in SAVE now, you have two options. You can always stay exactly where you are and take advantage of the fact that there are no payments due. Just be aware time spent in this forbearance does not count towards forgiveness, and interest began accruing again on August 1st. So if you are pursuing forgiveness, you need to explore your other income-driven repayment options now. Whether or not you choose to do it right now and switch is up to you, but you at least need to be aware of what they are. Once the SAVE forbearance ends, you will be forced to make a choice. And if you don't apply for a different plan before October 31st, 2025, it is very possible that you will be transitioned to the 10-year standard plan, which could be incredibly expensive for some of you, especially if you have higher loan balances. So you definitely want to know what you're going to do. All right. And then what is your overall repayment strategy? If your plan is to repay your loans in full, consider a traditional plan such as the standard or extended plan to have the quickest payoff time and the least amount of interest accrued. If you plan on pursuing income-driven repayment forgiveness or IDRF, you need to choose between IBR, payee, or ICR. Just remember that payee and ICR will be phased out by 2028, so you will need to switch eventually, but you can be in them for now. The safest option that we've been trying to steer the most borrowers to is IBR. This will be the only surviving plan after payee and ICR are gone. It calculates payments differently based on whether your debt is from before or after July 1st, 2014. But if it is your cheapest option, we recommend enrolling as soon as possible. Any qualifying credit you earn towards income-driven repayment forgiveness under SAVE, payee, or ICR should be transferred over, and you can keep accruing credit under IBR if you switch. And then if your plan is to pursue PSLF, then you need to be enrolled in IBR, payee, or ICR and continue making your payments on time and in full. If you are in the SAVE forbearance and pursuing PSLF, it does you no good to continue sitting in this forbearance. IBR is the safest plan, but if your payments are significantly cheaper on one of the other plans, please choose your cheapest option. Due to long processing delays, you may be placed on a processing forbearance. You don't have to request this. This is automatically placed by your servicer for up to 2 months if they can't process your request in time for your next billing date. So if that happens to you, those forbearances do count towards public service loan forgiveness. So if you've already hit your 120 months of service, as we talked about before, and you don't have 120 qualifying payments, you should submit a buyback request. Even if they're being processed very slowly, even though there's not much movement on them, it is definitely still worth it. And then selecting WRAP as a plan. When that becomes available next summer, it may be a cheaper option for you than one of the existing repayment plans. However, it is unclear based on the current guidance if you'll be able to switch out of WRAP and back to IBR once you've entered it. However, many payments under WRAP, all payments under WRAP are going to count towards any forgiveness program, and any previously accrued credit should be honored if you decide to switch to WRAP. The only difference is that WRAP only grants forgiveness after 30 years, when forgiveness under IBR is 20 years if you're a new borrower and 25 years if you're an old borrower before July 1st of 2014. So your payment may be cheaper, but it could be a longer path to forgiveness if you decide to put yourself on WRAP. And then if anyone takes anything from this presentation, if you are an existing Parent Plus borrower, especially if you are someone pursuing forgiveness, 7/1/26 is such an important deadline. Under the new terms of HR 1, existing Parent Plus borrowers must consolidate before this deadline if they want to retain their access to income-driven repayment. In most cases, this is going to be the ICR plan. That's the only one that Parent Plus borrowers currently qualify for. New Parent Plus borrowers will have no access to WRAP or the modified version of IBR, and they will have no path to forgiveness. If you do not want to be part of this group, you need to consolidate. So please reach out to us to start the consolidation and IDR enrollment process. If you plan to take out additional loans for fall of 2025 or spring of 2026, consolidate immediately upon their disbursement. If your Parent Plus loans are in default, now is the time to consolidate or remove them from that default and enroll in an income-driven repayments plan to lock yourself in. If you plan on taking out additional Parent Plus loans after July of 2026, you will have to pay your entire debt balance back in the standard plan. You have now classified yourself as a new borrower. Be strategic about future borrowing. If you are pursuing forgiveness, it might make more sense for you to take out a private loan to finance your child's education. We don't normally like to say that, but it is the reality. Parent Plus borrowers are like the one exception. They've just been systemically left out of all reasonable options, and especially new ones. It might just be your best option to go private. But definitely consult us first before doing that. All right, so there's also a program that exists for those that find themselves disabled and unable to pay back their student loans because they are prevented in some way from making a livable wage. So this probably won't apply to most people on this webinar, but if you have any disability, whether it's mental or physical, that prevents you from being able to work in a full-time capacity, there is a discharge program that forgives your entire balance if you're on Social Security disability, or you can also get it with a physician's signature. You can apply through the studentaid.gov website and get your form signed electronically by your doctor, or you can also do it through the website and have them signed manually by your doctor, and you can upload them. You can also apply just all on paper using the PDF application, but you do have to mail, fax, upload the paper version. It's much more difficult. If your doctor is willing to sign that form electronically, it is the easiest option. So please feel free to reach out to us if you have questions, or you can also refer to the FAQ page on studentaid.gov for more info. And then lastly, let's talk about what to do if you are in delinquency, default, or if you currently have collection judgments against you. So the first thing is we have to determine whether or not we're even in default delinquency. So when you sign into studentaid.gov and you see your balance in that little box, you can click the option that says view details, and then it shows you every single loan that you have and what status it is in. It's important to know what these statuses mean because it can kind of help you determine if you're in danger of being in default and eventually having collections against you by the Department of Ed. So if you look at your loan status and it says in repayment, deferment, forbearance, grace period, which is that 6 months after you leave school, in school, meaning that you're enrolled at least half time as a student. Those are all safe statuses to be in. You do not have to worry about collections. You do not have to worry about default. If your status says delinquent, this means that you've missed one or more payments, but you have not yet defaulted. You need 9 months of delinquency in order to reach default status. It's not an ideal status to be in. It's not technically considered good standing, but we can still fix it. If your status says defaulted, that means that you have not made a payment for over 270 days or over 330 days if you're a FEL borrower, and your loans have been transferred over to collections. This is not a good status to be in. And you are subject to possible collection activities. So we want to make sure we remedy that as soon as possible. All right, so what should we do if your loan is delinquent? Meaning that you've missed at least 1 month of payments and your account is considered past due, but you are not yet in default. If you can afford your monthly payment that you've been billed and you just forgot, or you didn't know you were even in repayment status, you thought the COVID-19 forbearance was still happening, whatever it might be, issues with auto debit, we see stuff all the time. You can call your servicer and request what's called a retroactive forbearance. This may resolve any missed payments that are on your account, and it will bring your account current again. Student loans are not like other consumer debts. You don't have to pay your entire past due balance in order to become current again. You can just get them back in good standing by calling your servicer and then making your next payment on time and in full. If you cannot afford your monthly payment, that's a different thing. You need to review and update your repayment plan if you can. Explore income-driven repayment options if you're currently enrolled in a standard plan. That's always our first option. If you are not on income-driven, see what is affordable for you. If you cannot afford any of the payment plan options available, whether it's standard or traditional, this is actually much more common than you think, and I have plenty of clients that are in this boat, then you need to request deferment or forbearance on your loan. Deferments are preferred if you are eligible for them because interest doesn't accrue on them if you have subsidized loans. They do if you have unsubsidized loans, but regardless, payments stop on them. Forbearances also stop you from being billed and they keep your account in good standing, but interest does accrue on most forbearances. All right. So consequences of default. If you choose to ignore your delinquency status for 9 months, you will end up in default. Your debt becomes payable in full immediately. You've lost all your opportunities to enter income-driven repayment, to request deferment or retroactive forbearances, and you cannot accrue any credit towards forgiveness in this status. You will also lose access to federal aid. If you try to go back to school or continue your education, you will have to resolve your default first. The federal government is unique because they have a whole set of collection methods that prevent that private lenders maybe you don't have access to. They can intercept your tax refunds. They can offset your Social Security benefits. They can garnish your wages. They have access to federal assets like bonds, all in order to pay off this debt, and they will go that far. So tax refund intercepts began again as of May 5th, 2025. If you already got your tax refund for 2024 before that date, you are safe from this. You don't have to worry about it this year. So you still have time to resolve it. Social Security offsets are currently on pause for this foreseeable future, but they can also be turned back on any time. So it's important if you have take advantage of this time that they're not collecting to get your status back in good standing. And then wage garnishment notices are set to be sent out within the next few weeks. If you are unsure about whether you're scheduled for collections in any way, you can call the Treasury Offset Program at the number listed on the slide, and they will let you know whether they have collections set for you. So you can kind of make some decisions about how to get out of default. So there are two ways that you can get yourself out of default. That is either through consolidation or rehabilitation. There are pros and cons to both of these options, but everyone's situation should be evaluated individually because it gets very complicated. Loan consolidation is a much quicker option. It can be completed in less than 3 months. It doesn't cost anything to consolidate. Default has a negative impact on your credit overall, and loan consolidation will not help remove any delinquent or defaulted marks on your credit. But it does restore your your eligibility for financial aid, income-driven repayment, and forgiveness immediately after the consolidation is processed. However, it will restart your payment count towards income-driven repayment forgiveness, and you'll only get weighted average credit towards PSLF, meaning that it could possibly lower your PSLF payment count if you that you had from pre-consolidation. So it's very important if you're pursuing forgiveness to talk to someone before you decide to consolidate. The number of times that you consolidate depends on how many of your loans are in default and what types of loans you have. You can do it more than one time. It just depends on how you do it and what's in default. But consolidations can stop the offset of your Social Security benefits. However, you cannot consolidate your way out of wage garnishment or a collections judgment against you. The other option for getting yourself out of default is loan rehabilitation. This is a much longer process where you make 9 on-time, in full payments within a 10-month period, and it will bring your loan back into good standing, and it removes any defaults from your credit report. It also restores your eligibility for financial aid, income-driven repayment, and forgiveness once it's complete, and you also maintain any existing credit that you had towards forgiveness before you defaulted, unlike consolidation. So right now you only have one opportunity to rehabilitate a loan, and throughout the life of the loan you can only do it one time. But after July 1st of 2027, you will have 2 chances to rehabilitate a loan. Rehabilitation can stop wage garnishment and tax offsets after you make 5 out of 9 of the required payments. So it is also an option. But please consult EDCAP before choosing one of these options, especially consolidation. All right, and then how to contest an offset or a garnishment. First, you can request a hearing. You have the right to a hearing before or after the offset or garnishment begins. For garnishments, you have 30 days from the date of notice to request that hearing. After 30 days, the garnishments may start, but you can still pursue a hearing at any time to stop it or reduce it. For offsets, there's no strict deadline, but once offset occurs, it may be very difficult to recover funds that they've already taken. You would ask for the request to stop or reduce offset or Social Security benefits packet if you are claiming hardship, which is what most people claim to get it stopped. You submit a written request to the loan holder or the collection agencies listed in your notice. Some of the common grounds for disputing these is that you've already repaid the loan or you are not the borrower. You're experiencing financial hardship, especially for Social Security garnishment or wage garnishment. You've entered repayment or are on track with some kind of agreement to pay off the loan, or the loan is not legally enforceable. For example, you filed bankruptcy, you put in borrower defense application claiming that the school wasn't even invalid or performing in good conduct to begin with, or some other kind of discharge. But you need to be prepared. You will have to provide supporting documentation, including tax returns, pay stubs, loan records, proof of repayment. It is a bit of a heavy burden of proof. They also ask for expenses and income details, so they really get pretty detailed into how you spend your money in order to contest one of these. Right, and then this page is just some relevant links to some of the stuff that we talked about today, some of the FAQ pages, some more detailed information about some of the more specific programs. And then we have our contact information. So I've probably said it about 10 times throughout the presentation, but we have an entire network of student debt counselors ready to assist you with anything that we presented here today and even more. We've helped thousands of borrowers since our program began in 2019. On the screen is the contact information for Empire Justice Center. Email is by far the easiest way to book a free, unbiased one-on-one student debt counseling session with us. Our attorney, Sandy Budd, and I are happy to assist you with anything related to federal student debt. Although we didn't cover it today, we also assist borrowers about private debt and also direct to school debt. So please feel free to reach out about any higher education issue that you're having, even if we didn't talk about it today. All right. And do we have any questions? Let's see here.
So there was a really good question that I'm like, oh, no one has ever asked me. And that is, can you place auto debit for a higher amount than what you're required to pay? And I don't know the answer to that because most of the time bars don't have extra money to pay, but you can go to your servicer website and play around with it. Obviously, your servicer would be the best source. I know that you can make extra payments at any point through your servicer account, but I am not sure if you can do auto debit for a higher amount. You might be able to. There was a question about someone having multiple loans and whether they should consolidate. So we are at a point now, given the current climate, where we recommend you follow up and get a session to see whether you need to consolidate. And when I say you need to, whether you would benefit from consolidating. I will say that as a general rule, if all your loans are direct and you can check the loan type by going to your studentaid.gov account under My Aid, there's going to be a little section that says loan type. If they are all direct, chances are you don't need to consolidate, you're fine. Um, Consolidation might be most appropriate for people who have older loans. Um, and the loans that you would be looking to consolidate are more like FELP loans, FFEL. So be aware that you might not need to consolidate, and we probably recommend you get advice before you do it if you're planning on doing it at this point, especially if you're pursuing public service loan forgiveness. There's some repercussions there, or if you're pursuing income-driven repayment forgiveness. If you consolidate, you may lose some credit already earned. So just be aware of that. And you can reach out obviously to Jordan and us at any point for a session. Uh, okay, let me quickly, I think we have a minute to unmute someone. Amaris, you can unmute you should be able to speak now. You can unmute your mic if you want to ask a question. Okay, no questions. Okay. Um, I think that was it from my end. Jordan, feel free to wrap it up. Okay.
Yeah. Oh, do we have one come in? What about if you're not in New York?
Okay, so you can reach out to the EDCAP website. There is a referral process for people who are not in New York where we can refer you to someone who can give you one-on-one. We are state funded, so we have to focus on New York, but we won't leave you out in the dark. We can give you a referral for someone who's competent and can assist you as well. So reach out to via the EDCAP contact. Or if you reach out to Jordan, feel free to flag it for us and we can get them some help.
Absolutely. Anyone else for right now? Okay. Well, thank you so much to everyone for coming. Thank you so much to Assemblymember Romero for having us. Please look out for an email from us at Empire Justice Center with a copy of the presentation and also our contact information again in case you need anything from us. And we will talk to everyone soon. Have a great rest of your day. Bye, everyone.